My name is Natalie Luera. I'm an Associate Attorney at West Mermis in Houston, and I work with general contractors, subcontractors, and owners regarding construction disputes. I want to take a couple minutes to talk about arbitration, what it is, why it's commonly used in construction contracts, and why it might not necessarily be the right fit for you. At a high level, arbitration is a private alternative to court, and you present your case in front of a private arbitrator or a panel of arbitrators for them to make a final binding decision. So why do owners or contractors often choose arbitration over just simply going to court? First, industry experience. For the most part, parties have a choice when determining who their arbitrator or arbitrators are going to be. This means that the arbitrators will have industry experience in whatever it is that you're going to arbitration for. So you do not have to explain to a judge or a jury the intricacies of your case. And these intricacies may involve change orders, pay applications, delays, and defect claims. Second, efficiency. Litigation can drag on for years. Arbitration, however, lets the parties control the process. This means streamlining discovery, setting deadlines, and focusing on the issues that really truly matter. For owners, it means fewer disruptions to projects or your project portfolio. For general contractors and subcontractors, it means simply getting back to work and resolving disputes faster. Third, privacy. Court proceedings and lawsuits are public information. However, arbitration is private, and arbitration awards are very difficult to appeal, which means disputes actually end without years of post-trial motions or appeals that can take time and money. That said, arbitration isn't always the right decision. Situations where arbitration might not be the right decision for you is if you have very complex and broad discovery, there are multiple parties that need to take part in this discovery, or you want the ability to overrule a legal decision. It's also not a great decision for you if a dispute involves novel legal issues. Arbitration may not be ideal when there is very broad discovery that needs to be conducted, or there are multiple parties that need to participate in the arbitration, or there are novel legal issues that you need to handle, or you really do want to appeal that final decision because, like I said, arbitration is very hard to overturn or appeal. This is why arbitration provisions in construction contracts, specifically AIA contracts, is very important. Simply checking the arbitration box might not be the best decision for you. You need to take a good look at your business and why arbitration is good or not good for it. The key takeaway is this: arbitration is not simply a legal decision, it's a business decision. If you're negotiating a construction contract, simply updating your terms, or you're already involved in a dispute, it's important to reach out so that way these issues are not pushed down the road any further. If you have any questions about arbitration clauses or tailoring them to your specific needs, reach out to me at West Mermis. At West Mermis, we work with general contractors, subcontractors, and owners, and we are very happy to be a resource that you can use.